So royalty is not a tax, but it is already the share fixed by the MMDR. And since that is tapped, that is why that context, as a sort of a paraphrase, it was said that royalty, in that sense, is akin to a tax on mineral rights. And then it became the catchphrase became royalty is a tax. So my Lord, the Chief Justice is right. I'm not saying royalty generically is a tax. That may perhaps be, my limited legal skills don't allow me to go that far, my Lord. Maybe somebody may be able to develop that point, I can't. I'm not conceding anybody else's case. My limited intelligence, my Lord, doesn't permit me to develop that point.
Tax, but it's an exaction by the state of a share of mineral
rights. And if it is construed like that, and why was this not created in 35? It's something I have to address, Your Lordship, fully, because one can't just read the plain language. You have to see where it came from, how it came, and what are the legal framework in which this was introduced. And if you construe it that way, the whole thing just falls into place. Why was Section 25 put into the Act? Treating royalty and tax in the same breath as an exaction. Why a penalty and a prosecution for non-payment of royalty?
When you speak about how it came, we cannot also be forgetful of the Constitution Assembly debate when it was deliberately kept within the state's power, the power of taxation.
Yes.
Although a suggestion was made that it should be brought to the union powers list.
My Lord, I'll tell Your Lordship why. I'm sorry, I'm digressing because there's a full dress argument.
But you may address it at the appropriate time, because you talked about time.
I must tell you why. Because one idea was move minerals to the unions.
That's right.
They said, no, we will keep minerals the same way industries, minerals will be kept to the states with the overriding power to call. In fact, one of the big criticisms has been industries. The declaration in the Industrial Development Regulation Act pretty much wiped the state clean. And that has been the problem.
But tell us this, Mr. Salve. I mean, this is just, it may be a conceptual issue. It's not necessarily against you. I just have this doubt. Suppose when the state taxes income.
Yes.
Is that to be regarded as an exaction of the income? Or suppose a state, there's a tax, there's an excise on manufacture. It's not an exaction of the value of the article manufactured. Or suppose they tax corporate profits. Of course, the impact is that you're taking a share of the profits. But it's not an exaction of your profit.
Excise duty was in the old, if you go back to the historical definition of excise duty, the word excise was exacting. Exaction.
It's a tax. It's an imposition.
Of course, all exactions, all taxes are exaction.
Yes. The levy is a tax. The levy is an imposed tax on a particular subject, whether it's income or the value of the article manufactured, or services rendered. Now, in the case of the goods and services tax, but you can't say that the state is exacting.
I'm sorry, ma'am.
If they tax us for our income, they don't take away our income. It's a tax on the income which you earn.
No, I'm sorry, I didn't mean it. Every tax is an exaction. Exaction by definition means something which is compelled by law, not something which you do by contract or voluntarily. So in that sense, it's an exaction by law. But not the share, land revenue, for example, and when I deal with the Murthy aspect of the case, land revenue, for example, is said, what is land revenue? It reflects the sovereign share of the produce. That was land revenue. And when it comes by law, it becomes an exaction. So today a land revenue law is the shares, an exaction by the state of a share. Today, of course, the notion of a state has changed. It's not like a king or a sovereign. Today it's a welfare state, etc., etc. But conceptually they remain the same. But this is the third point which I'm going to develop now, about what is exactly a tax on mineral rights in the Indian context. So there are three independent elements. The first two go together purely as a matter of interpretation of entry 50 and the interplay. Yesterday, my Lord, the Chief Justice asked me, why are you showing these cases? The interplay between 5423 and entry 50. Today, my Lord, the state, and it will have some bearing when it comes in the context, but I'm just mentioning. Today, the state is the owner of minerals, but it cannot alienate its mineral rights. If the state wants to make a legal framework for alienation of its own mineral rights, it can't. Because if it had to make, it could either do it as an owner if there was no law on the field, then the law of contract would prevail. Or if the state wanted to make a legislative framework for alienating its ownership rights, it would have to reach to entry 23. Because as an owner, you can't make a law. You would have to find something in lease 2. And that only place where they would find it is entry 23. And if 23 is swamped, the state is the owner but has no right to alienate its own mineral rights. So these are all, sorry Manoj, I got a little ahead of myself. Let me come back therefore to the starting point of my submission so that I'm able to go down logically. There are 3 elements, therefore I say, in this entry which require rigorous analysis. The first 2 go together.
Can you just again formulate them?
Yes. Not on a lighter vein, since nowadays we are all on YouTube when we are arguing here. And on social media, there is a brown colored liquid which my daughter has sent, which is for my throat. It's just that. Because I remember somebody had put up on one of these law websites, counsel drinking coffee. I wanted to clarify, they shouldn't say he has come from London, he has done what English barristers do, carried something in a class. The first is, it is taxes on mineral rights, and I put it on bold, because that's what your lordship will have to analyze. What is a tax on mineral rights? The second is, what is the kind of limitations which our founding fathers had in mind when they used the phrase of great width, any limitations? Not just limitations, any limitations. Why did they say any limitations? And the third is, they did not say imposed by law by parliament. They made it descriptive by law relating to mineral development. I have to now establish, in order to succeed, that there is a law relating to mineral development, which there is. I don't think there's any cavil on that. And that such a law imposes those limitations.
The only one thing which we'll add to your second point, the law imposes those limitations
on the tax.
On the tax on mineral rights.
I want to start with that. In fact, Manoj, that's a point which, for want of a better expression, cuts both ways. I say it cuts my way for the following reason. We know that taxing laws generally operate in a field distinct from laws relating to regulation. We start with that premise. So that's an established constitutional premise. How will then a limitation look like on a taxing power if that limitation is to be found in a law relating to mineral development? What kind of limitation are we looking for? It is not a tax versus tax limitation. It's not Parliament saying we have shared, therefore I will tax it rather than you taxing it. I mean, that's what your lordships have held. Now Parliament can't tax it. No, that's a separate argument I'm going to address on what I call the Kannadasan conundrum, on whether they were right, whether the judgment saying because 50 is denuded, it lands in 97 is right or wrong. That's something your lordship will have to consider. But let's take it without any of those trappings. What should we be looking for? I start from there. Here you have a taxing law, but then you're told look at any limitations which may arise from a law relating to mineral development. Any limitation. So what are those kind of limitations which would arise? And that's where there is Malad offer the answer. Well, if the manner in which the law relating to mineral development is cast covers all aspects of mineral development, including the share of the state from the resources.
Just one second.
I'm so sorry.
So I took down is the manner in which the law relating to mineral development is cast includes all aspects of the matter, including the share of the state
in the mineral resource. That would then, and then a tax on mineral right. And why was all this brought? This was all brought, it was federalized, if I may coin that expression, rather than leave it at the state level, because of the uneven distribution of resources.
The way I formulated it is, if the manner in which the law relating to mineral development is cast includes all aspects of the matter, including the share of the state in the mineral resource, that would exclude the power of the state to seek any further exaction on mineral rights.
Yes. Because ultimately, if we take a step back, you may call it tax on mineral rights, but what else is it? It is the state monetizing a resource. Land, tax on land, the state is and for public good. We all know today's states levy tax for public good, at least in theory. Not for enriching the coffers of a ruler, but for public good. So, and today, Ballard, with 9B and 9C sitting there, including local development funding being raised under a law for mineral development.
But Section 9 is only one kind of exaction.
Of course.
It is not all encompassing.
No, Malad, it's not. 9 is not the complete answer.
It is only one type, royalty.
Of course, Malad. Sorry. No, I'm sorry. 9B, 9C.
9B.
9B, 9C.
Yes. I'm only showing.
So what you are saying is that where Parliament wanted that the revenues of the states should be supplemented further.
Yes, it
in
has.
relation to mineral rights. Then they have been given different types of heads for realization.
And Parliament has done it. Now, the
So
import.
9 includes royalty. So really your argument is much more nuanced. You are not saying royalty excludes the fact that Parliament has imposed a royalty which can be realized by the state excludes the taxing power.
Correct.
But that where Parliament wanted to create additional heads of revenue for the states, it's doing so.
And Manoj, this has been.
Mr. Salve, 9B goes to a foundation which is completely independent, and 9C goes to a trust. It doesn't directly go
In
to
fact, a lot of the laws, when your lordship see, which have been struck down, were the 9B kind of laws, where they created, you may call it a foundation, a district mineral foundation, or you may call it a separate head, by which the state keeps it and uses it for demarcated funds. That's how these cesses work. I'll show Manoj when I show the state legislation. 9B is pat what the states have been told you can't do now. I mean, subject to what will your lordship take on Kesoram versus India Cement. So, my submission is on a construction of entry 50. I'm sorry if I take a step back, therefore. I should be able to show that, first of all, Parliament has federalized this. Parliament does nothing under entry 54 and says, I leave it to the states, it is left to the states, untrammeled. A state may itself impose limitations on mineral development, but that's not good enough for 50. Suppose not 54 or not there, you can have under 23. Could I argue that under 23 this is done, therefore there is no limitation? No. Imposed by Parliament by law. So it limits it to a legislation referable to entry 54.